very warm welcome to you, everyone. Welcome to EBC Learning and to this interesting webinar on a very important case, Municipal Corporation Ujjain versus BVG India Limited. And we have with us today Dr. Charu Mathur. Let me introduce our speaker, Dr. Charu, to you all. Dr. Charu has a rich and diverse expertise in corporate, commercial, civil, criminal, and constitutional law matters. She's an advocate on record, Supreme Court of India. She has represented parties which include cricketing bodies and educational institutions like IIT Jodhpur, NLU Jodhpur, and other private engineering and medicine colleges of Gujarat and Orissa. Dr. Charu is also a passionate academician and has authored various courses at EBC Learning. She has done courses on corporate law, various modules on insolvency and Negotiable and Limitation Act. Dr. Charu has already conducted 3 more successful AOR courses at EBC Learning. Very high percentage of our students have already succeeded in the exam under her guidance. Our 4th batch for AOR exams will start on 3rd of October. You can sign up with us for the course. I'll share more details on this. Give me a moment, please. So this is our course and you can enroll by 2nd of October. The start date is 3rd October here. End date is 26th of October. It's a 3 weeks course, 6 hours per week. All the details are there on our website. And if you want to know more about the course, I'll just, give all the contact details in our chat box and you can contact us. More from Dr. Charu on the course and on the session. Thank you. And thank you so much. Over to you, Dr. Charu. Thank you.
So good evening, everyone. Warm welcome to our webinar. Today I will be covering Municipal Corporation Ujjain versus BVG. Now, this is a seminal case. This is one of the cases which was added last year in the list of reading papers. So I assume most of you are the AOR aspirants, right? Right. So last year there was a question on this particular paper itself, on this case itself, because it is a new case which you must, I'll just read the case to you. So the question which has come on this was to summarize the law laid down in the case of Municipal Corporation Ujjain versus BVG and High Court's powers regarding the scope of judicial review on the opinion of expert body on technical qualification of a bidder and independent evaluation of technical and financial bids at appellate authority. So this was one case which had come from the new cases. So generally up till now, we were getting more and more constitutional cases as the part of the leading cases. But since the last year, we are getting a lot of commercial matters as well, which are coming before which are coming in this AOR exam. Now, so I'll just share the presentation with you. So now to start with, this is an important case. Now in this case, I mean, you must have done some of the other tender matters. There is a bid. So in this particular case, a bid was invited by Ujjain Municipal Corporation. So it issued a NIT, that notice inviting tender for appointment of agency to collect the municipal solid waste. Now this was a tender which was given for door-to-door collection for 10 years. And there were 2 parts of the tender. One, you have to give it in the tender, one in the technical bid, and another you have to get as a financial bid. Now, only if you are successful in a technical bid, only then you can go ahead with your financial bid. Only then your other envelope will open. So it appointed art as the technical expert. In this case, respondent number 2 was EcoSafe System Private Limited, who was a technical expert in the waste management, and it scrutinized the various bids that were submitted. Now, this was, I mean, if you have seen the global tenders, this was in that format only, that there is a technical bid for which the evaluation contributed around 80% and financial bid would contributed around 20%. And there were various scores that were given. There were a lot of parameters, as they say, and you need to order. Now, one very important aspect of this was that financial bids of only those bidders who secured at least 60% marks in the technical bid, they were allowed to be open. So in this case, So in this case, the respondent BVG, it just got 58.94 weighted score in the technical bid, while the successful bidder, Global Waste, it got 67.36 score. Now the problem was that the bid was given, and there was another issue which was regarding that a consortium can also apply. So once the bid was given, the unsuccessful bidder, respondent number 1, before the Supreme Court, BVG, it approached the High Court under a writ jurisdiction and saying that this bid is not proper and it should be cancelled. So High Court allowed his writ petition, and this impugned judgment was challenged before the Supreme Court. It was heard by bench of 3 judges. And when the matter came up, you know how the Supreme Court works. First, there is a notice, once the SLP is there, so Supreme Court decides whether this is a fit case to interfere under Article 136 of the Constitution or not. If it says it is fine, then it will issue a notice. And if it is fine, it's worthwhile, it will issue a notice and stay itself. So in this particular case, notice as well as stay was done, and the successful bidder, he was awarded the contract and he continued to discharge the duties. Meanwhile, the matter remained pending before the Supreme Court. Now, there were certain points which were formed as a question of law. So that is why I say it is very important for you to read the case laws, because with this, your drafting paper will also get prepared. So here you will understand how these question of laws were formulated. Whether under the scope of judicial review, the High Court could ordinarily question the judgment of the expert consultant on the issue of technical qualification of a bidder when the consultant takes into consideration various factors, including the basis of non-performance of the bidder. So, you know, you have to formulate. Our question of law, it starts with whether and whatever the question is. Or usi ko, when you want to convert into the grounds, you convert into because. I mean, this is just a tip that I am giving to you. So I mean, everybody has their own way of drafting their petition. So this is just one of the ways. Now the second is whether a bidder who submits a bid expressly declaring that it submits the same independently and without any partners, consortium or JV can rely upon the technical qualification of third party for its qualification. And finally, the question of law which was before the Supreme Court was whether the High Court is justified independently evaluating the technical bids and financial bids of the party as appellate authority for coming to this conclusion. So you understand what is this case all about. This is a case about the judicial review. So there is a bid was invited for waste management solution of a particular municipal corporation. There was an expert body which was there. This expert body, it was opening up the bids and it was evaluating. There were some conditions. First said that you have to give technical as well as financial bids. In the technical bids, you have to give only if you score above 60%, then only your financial bid will open. So the unsuccessful guy got less than 60% score in the technical bid, and hence his financial bids were not evaluated. While the successful one got the higher bid, and of course his was evaluated. Now coming on further, whether it is the case, whether there is can a party rely on a third party's technical qualification when they are not part of the consortium, when they are not part of a joint venture? Can they rely upon their technical qualification? And most importantly, can a High Court is justified in independently evaluating? So it is taking the function of an expert to determine if there is the financial and technical bids were proper. It is acting as an appellate body for coming to this conclusion. Now, when I talk to you about judicial review, you must remember that the key case for judicial review is Tata Cellular versus Union of India. So in Tata Cellular, the Supreme Court had come to the conclusion that for judicial review of the administrative decision, which requires related to tenders and award of contracts, there it has to be, courts can interfere in the contractual matters when there is a arbitrariness or there is a favoritism. Now, in this particular case, there was a galaxy of senior counsels who appeared, and allowing the appeal, the Supreme Court held that when the tenders were evaluated and the contracts were awarded, so these are essentially a commercial transaction. So if the decision relating to award of contract is in public interest, the courts will not, in the exercise of power of judicial review, it will interfere even if there is a procedural aberration or error in awarding the contract. So here the court says that even if there is a procedural aberration or there is an error in awarding the contract made, still the court will not interfere. Court went on to say that the power of judicial review will not be permitted to be invoked to protect private interest by ignoring the public interest. So the paramount feature is your public interest. Then court went on to hold that judicial review should be avoided if there is no irrationality or arbitrariness. So the test of judicial review is twofold. First is your public interest, and second is there is an arbitrary exercise of power. So court examined this case. This was by a 3-judge bench, and perhaps one of the last judgment by Justice M. Shanta Godkar. This was perhaps one of the last decisions which were given by his lordship. And in this matter on hand, the court found that there is no illegality, arbitrariness, irrationality, or unreasonableness on the part of the expert body while in action. So there is no bias or malafide either on the part of the corporation or on the part of the technical experts while they are taking this decision. So in this case, are you guys able to hear?
Yes, ma'am.
Mr. Agarwal,
Yes,
the
ma'am.
problem is it at your end only. Right. So in this matter, there is no illegality, arbitrariness, irrationality, or unreasonableness on the part of the expert body. And so the court held that there is no bias or a malafide either on the part of the corporation or on the technical expert while taking this decision. So court held that this is a case where the court will not interfere, will not exercise, the High Court should not have exercised the power of judicial review. Now, in this particular case, how the Supreme Court arrived on this decision? In this particular case, Global Waste Management Cell Private Limited, it got the highest score of 84.36 and it emerged as an overall eligible bidder for awarding the project in terms of NIT. Consequently, it was declared as the top one or L1 as they said in the terms of NIT. A decision was qualitatively arrived by technical expert respondent number 2, and the Supreme Court categorically held that High Court need not go into the merits of such decision as an appellate authority, especially when there is no allegation of bias or malafide. The bidder, the NIT was detailed enough to set out the details of any firm or company involved as a consortium member, to which respondent number replied in negative. So it has not fulfilled its duty. Like if it wanted to go with some consortium or some joint venture partner, then he should have expressly done so, which even the NIT provided, but it failed to do so. Right? So this is an important thing. Now, coming on to the next part, the respondent number 1 submitted that the bid on its own were accompanied by the consortium member, despite the same was allowed to be furnished by the with a certificate of the third party. Therefore, the reliance which was placed by respondent 1 on purported experience certificate. So he even put the experience certificate of the people who were not his partners. So they said, obviously, we cannot look into the third party, how their expertise will help him. So either you make them a partner or you go as a JV, you go as a consortium or whichever way. But you just cannot put any XYZ person on this, say that I will be relying on such person's technical expertise. Then the court went on to hold that authority concerned is the best person to decide what is the best for the work. Best quotation will depend upon the work, right? It is not necessary to choose an undeserving person even if he bids at the lowest. So there is no compulsion for the court to compel the authority to choose undeserving person to carry out the work. Ultimate thing that the court has to do is to protect the interest of the public at large. So until and unless there is an arbitrariness, there is a mala fide, there is a bias, the court should not interfere. And even otherwise, courts are very clear that they should not interfere in the cases of where there is a mala fide is being alleged. In commercial matters, in contractual matters, the court should restrain from exercising court should refrain from exercising this writ jurisdiction in particular. So courts are slow. If you have a remedy, like even for your contractual matter, you have a remedy under the civil law. I think writ jurisdiction is being, to say the least, writ jurisdiction has been abused a lot by each one of us, all of us lawyers. The first thought when the matter comes is to file a writ petition. There are other proper remedies which are available that a party should avail. So in this case, the court held that it is clearly a case of a case where there is no judicial review is formulated. So this is all that I have to explain. This is a short judgment, but a very important judgment, because judicial review is something which is the essence of our constitution, right? If you compare our constitution with the other world constitutions, you will realize that not all the constitution gives you the power of judicial review. So judicial review is, you can call it as a part of our basic structure also. So this is a small judgment, but a very important judgment that is for your AOR examination. So this is all that I have to give you on this short case. And if you have any queries on this, then the floor is open to you.
Madam, this is the enough for to write the examination. What you have stated the facts, question of law, and held some points.
That is enough. The court does not want you, the board of examiners does not want you to just fill the pages. They want the substance. And you should be precise that this is being asked, and this is the answer to this question.
Some more case laws also mentioned in this case, madam. Not only the Tata Cellular, some other cases also mentioned. Does it require to mention more than 1 or 2 cases, or it is sufficient for 1 case?
1 or 2, when even they are asking you about this particular case itself, right? Yes. They are not asking you about the other cases. So Tata Cellular is one example that I just shared with you. It is not even
in Delhi Science Forum also one of the cases is there, madam. Delhi Science case is also mentioned in this case only.
Right, right. So this is an important matter that you will find. It is a short judgment, crisp judgment, but it has also given lot of judgments. It has cited lot of precedents in the judgment. So it is not necessary for you to go into all of them from the point of view of examination.
Madam, I would like to ask one question. From the point of view of examination, can you go for only for principle of law or principle of factors? Factors also necessary.
See, it depends on the question. What are they asking you? But you must know the facts and you must know the law. They will be providing you with the head notes in the examination. But still, if you have not gone through at least the head notes once, it will become very difficult task to do that thing impromptu in the examination hall.
Okay, but thank you.
Hello, ma'am.
Yeah, hi.
Yeah, when we talk about head notes, which journal they provide?
Supreme Court reports. That is the official journal of Supreme Court, SCR.
Very good. Thank you.
But in SCC, you will find more detailed head notes so that you
Completely.
understand
Yes, madam.
what it is.
Certainly, yeah. Right.
Where difficulty is there, we have been mugging up with by way of SCC judgments, but examination they are
They are
providing
providing
ACR
SCR. That is the difficulty.
head notes. That is the very
But
difficult.
if you have learned it, if you know it, what it is, so head notes are nothing. That is just the creativity of the person who is writing them. Essence is the judgment.
Yes.
And they are just trying to take out somebody, they would like take out 10 points from a judgment, somebody would like to take 5 points from the judgment. So if you are reading, then you actually don't need anything else.
Okay, madam. That is fine, madam. That is fine. Yes.
Notification has issued today, madam. Notification has issued today.
Sorry, yeah, notification, it has just come out.
Just now I have received the news from yeah.
Yes, madam. In the 16th of September has been issued, madam. And last date is November 1st
Now,
for submission of application.
Yeah.
Just now I have
And the
notified.
registered asked to submit a hard copy as well as the scanned copy also.
Soft copy,
This
yeah.
time.
Right. But they should do away with this hard copy business.
And we are required to submit both hard copy as well as
Yeah,
scanned
I know
copy.
that.
Soft copy,
But
first I have to file soft copy, then later within 2-3 days I have to file hard copy. also.
right. So you are practicing here in Supreme Court?
Not madam.
You are not practicing here?
Not madam.
No. And what about you, Mr. Saratana?
Madam, up to certain point I have been practiced, and now I have been preparing because I'm not supposed to practice. If I practice, my preparation will be go.
No, but you are Delhi-based lawyer. This is what I'm asking. You are Supreme Court.
No, I am not Delhi-based lawyer. I have came to Delhi on January 2021, and I have been practiced for a period of 1.5 year or maybe 2 years, and I now come to my home place for preparation.
Right.
I keep all the things as kept aside, and I am concentrating only preparation.
Yes, me too, madam. Me too.
Right. All the best.
Okay, thank you, madam. And your lecture is a great insight and great help to the AOR examination, madam. And we'd like to hope the more lectures from you, since there will be great advantages to the AOR examining community.
I'll try to do as many webinars as possible.
And eagerly waiting for you on the October 3rd, madam. We will be eagerly waiting for your lecture on October 3rd, madam. We have joined in EBC learning course also, just not day before yesterday.
Right. Great. Yeah, Mr. VP, you want to ask something?
Yes, ma'am. Vineet here. So
Yeah.
I was saying that will we get a recording of this session, which you have just taken anywhere?
You have registered for EBC Learning's AOR course?
The earlier one I was.
So I think you can just speak to Pradyum. I
yes,
think
very
you
well.
will be getting, you have not written the earlier exam, no?
No.
You are batch 3, no?
No. Yeah. I'm the batch which just got over.
Yeah, you will get, no problem.
Okay, very well. Thank you.
Sure. So any other queries? So on 23rd, we are having a lecture on Mafatlal Industries. So this is by Justice Vineet Kothari. He is a tax expert, retired judge now. And thereafter, we will be organizing, one of the lectures will be on Selvi, another will be on Gujarat Urja. Then one more I have lined up. It is on one of the common cause cases, and more I am lining up. So do check your mails, right? And then let us see. And I'll try to organize. See, we have got a limited time to discuss each case in the entire course. So what we have devised
That's we require. That's we need the crux of the case. That we need.
Right. So what I have thought is that we will go ahead with one case per webinar. Earlier also we have recorded some 10 or 12 cases are there, with whose access you will get. So we're trying to get experts on the cases to speak to you about this. And whenever you guys are in Delhi, do come and you can have a chat with me. I am in chamber number 29, RK Garg Block. Vineet, yes, your hand is raised.
Ma'am,
Madam,
that was
chamber
for the
20
earlier question. That was for the earlier question. Thanks for looking at it. Thank you.
Madam, you please repeat, madam, chamber number 29. Where
Yeah,
is it,
RK
madam?
Garg block, the main Supreme Court premises, chamber number 29. I have got one more
Okay,
chamber in the new block also, but that is not functional, obviously.
Okay, madam.
So currently it is 29.
Madam, will you conduct all the sessions before commencement of the course or in meanwhile after commencement of the course?
During course, in between course, after course, as and when possible. I'll try to organize as many webinars as possible. Dr. Achal, can we call it a day then if they have
One question, ma'am. One question.
Yeah,
Yeah, one question. I don't know whether it is applicable in this forum or not, but I just wanted to know that in general, when it comes to writing the exam,
Right.
how big a problem is the length of the exam? So is it actually an exhaustive, long-lasting question paper or?
See, question paper drafting me, you will get half an hour to read the question paper, right? But not in the other papers. So time management and writing with your hand is something which is essential that you must do. You must practice your past papers.
Very good. So this, over time, have you seen that this becomes one of the criteria of people not clearing it, is it? Despite knowing things?
That is the only criteria. That is the only problem. It is not that the paper is tough. People either they end up just deliberating on the question, whether it is right, whether it is wrong. You don't have to judge that.
Of course, right.
If there is an option, like I'll give you the example why I'm saying this. Last year's drafting question number 1, part 1, the first question in the choice. It was huge and people spent hour and a half just reading and analyzing it. And obviously they could not finish the paper. And many of the people, they just could not clear it. Many of them, people who have cleared bar exam, New York bar, solicitor, this, that, people who are in regular practice.
Very good. Yeah, so that is one of the trappings in that case. This is one of the most important trappings.
Another is we don't know how to write with hand. It has become after 5 years.
Right. So we mostly end up writing like children.
Right. And there were people actually with swollen hand. It happens every year.
Oh, okay. Thanks for this tip, ma'am. Clarification. Yeah.
Right.
Thank you.
Ma'am, a question. Hello, ma'am. I'm Pallavi.
Hi, Pallavi. Good. How are you?
I'm good, ma'am. Ma'am, finally, I will be giving the exam this year.
Great.
Appearing for the exam. So, but I thought that I'll study a lot since last year, but finally did not get the time. Again, it's like last moment, 3 months now. And like, I've set down to study, of course, but whatever I expected to study from last year did happen. It did not work out. Yes. So, ma'am, my question, as you just mentioned the drafting paper, the first question was very long. So, is it possible for us to leave that question, do the rest, and come back to that one later? Is that
definitely
we can do that?
And uske andar bhi choice thi. There was a choice. People just went on for thinking. I mean, we have one objective to clear the exam, not to check whether they have drafted the paper correctly or not.
All right, ma'am. Yeah. Thank you so much, ma'am. And definitely over the next days, whenever you have the webinars, I'll be attending, and maybe the questions will increase. So we'll ask you more. And please, so of course I'm not joining because I was there in the first batch of AOR. So I did not join this year, but I hope to attend all the webinars, ma'am.
Sure.
The case webinars.
Great.
Yeah.
And
thank
next
you.
webinar will be on the Mathur. It is a 9-judge judgment. So it is with the judge who has dealt extensively with text matters. So if you have a questions, you can read it. And he would like to have it as interactive as possible.
All right, ma'am. Sure, ma'am.
Sure. I think Pallavi,
so maybe we can textbook on Mathur.
No, I think you do tax litigation, right?
Many years back, no, not anymore, but I have to, go through it. Many years back, I used to do. Many years back.
Right.
Many years back. I used to be in a firm where they were specializing in tax matters. That's when I was a junior advocate at that firm. Yes. Yeah. Thank you so much. Thanks. Ma'am, but please do more of the webinars as many as you can, ma'am.
Sure.
It really helps out.
Thanks.
Thank you. Yes, thank you, ma'am.
So Sanatana, I think you were asking something.
Nothing, madam. And one thing is that since across the India, we don't have any offline or online coaching, except EBC learning is providing by way of this coaching, and very grateful to you as well as the EBC
Institution
for
also,
providing these inputs and insights. And in the Supreme Court, some materials are available, but whatever may be material, this first hand, this coaching, what is called some insights and inputs regarding examination is very much helpful and very much grateful to madam. And I am endowed with SCC online and AOR online, and my Andhra Pradesh, Andhra Law Times and Andhra Legal Decisions. That is all e-library. And recently I have gone through the LexisNexis Knowledge and LexisNexis Red also. So as far as myself is concerned, I have been preparing for the last 1 year. And so as far as myself is concerned, this is sufficient, I think so. And whatever the additional advantage by way of your lectures, this is, I'll definitely get the additional advantage.
Great, great.
And if I qualify the AOR examination, I'm much very obliged to express my gratitude to you also, madam.
Thank you. We hope that all of you qualify. Last time we were able to secure 15 of new AORs are ours.
No, this is the first attempt, madam. This is the first attempt.
But don't worry, we'll do fine.
Please, madam. Thank you. Thank you.
Madam, notification, even the last year also, paper 2, 3, 4 is mentioning, but even today also, the paper 1 syllabus is not mentioning the notification.
See, paper 1 is the, yeah.
Supreme Court rules and practice, madam. That is paper 1. What is the syllabus?
Yeah, that is standard. Practice and procedure.
Yes.
We will be doing, when we'll do the course, we will be covering everything. Right? Dr. Achal, can we call it a day now?
Sure. Thank you, Dr. Charu. I think we had an elaborate discussion and a very, very informative session.
Dr. Achal, I think I read somewhere in the chat, somebody wanted to have the link for registration.
Link, I have just shared my email ID. The link for registration, I need to check.
It's there on the website itself.
Oh, sure.
Beg your pardon, ma'am, which link is it?
I'll just
Link?
share.
For registering for AOR exam.
Okay, fine. Yeah, thank you.
So, okay, have a great day and keep on attending the webinars. And if you have any input to share, please feel free to give. We will try to do our best.
Thank you, ma'am. Thank you very much.
Thank you so much, ma'am. Thank you, ma'am.
Thank you.
Thank you. Bye, ma'am.
Thank you.
Thank you, Achal. Bye.